Welcome to the Pacific Research Institute's Next Round podcast. I'm Rowena Ichon, Senior Vice President, and with me is Tim Anaya, Senior Director of Communications.
Hi, Ro. How are you?
Fine, thank you, Tim. So the next series of podcasts we will be producing will be from our annual Sacramento Ideas in Action Conference. And this one coming up was a key presentation, and it was to launch PRI's new report on CEQA, or California Environmental Quality Act. So listeners may know that CEQA has been responsible for the holdup of many, many building projects in the state, not just new housing, but schools, hospitals, even bike paths, even projects for wildfire mitigation. So it's in desperate need of reform, and that's why PRI enlisted a group of top environmental and land use lawyers from Paul Hastings, led by Chris Carr, to offer ideas on how to reform this law, which is now about 50 years old. And they also created an amazing flow chart with the help of Dana Beagle, our graphic designer, detailing just how complicated the permitting and licensing process to get anything built in the state. And even when you dot all the I's and cross the T's, there are lawsuits to contend with. This was actually signed by Ronald Reagan, no less. But over the years, as Chris Carr writes, it's been weaponized. And as a result, it's impeded its growth in the state.
And we're seeing the weaponization right now, which with a case that has garnered statewide headlines and really sent shockwaves across the state, where a group of neighbors sued UC Berkeley over a classroom and housing project, and a lower court actually agreed with the neighbors, and they issued an order requiring the university to freeze admission at 2020 levels. And what this would mean effectively is that about 3,000 prospective students who were anticipating being admitted into Cal this fall will not. Last week, the California Supreme Court declined to stay the lower court's order. So the big question now is, what are we going to do for those 3,000 students? There are efforts already under afoot in the legislature to pass a bill and exempting University of California from having to go through all these hoops and environmental projects. But as Chris, in his report, that actually isn't what the legislature should be doing. Instead of all these kind of individual streamlining and exemption bills that lawmakers typically pass for notable or politically popular or politically favored projects, we should be taking an overall look at the problems with CEQA and pass reforms on a more comprehensive scale. And it's his hope that the public outrage that we have at this moment really will provide the incentive for lawmakers to finally consider the long overdue comprehensive reforms to CEQA. So this issue with the UC Berkeley project and so many other projects across the state in so many areas that are priorities for Californians, that they aren't commonplace, that we can work through these unnecessary roadblocks from CEQA. And for anybody, by the way, who wants to read the report or see our flow chart themselves, you can go to pacificresearch.org/CEQA, and CEQA is CEQA.
Thanks so much, Tim. So here's Chris Carr, and he'll be introduced by PRI fellow Nolan Gray, who is an urban planner. So thanks so much for listening. Here they come.
Our first panel discussion is on what we are calling the CEQA Gauntlet. CEQA, formerly known as the California Environmental Quality Act, has been identified by nearly all observers as a roadblock to building badly needed new housing supply in the state. But CEQA's regulations, lawsuits, and the threats of lawsuits are holding up new school construction, critical infrastructure projects, and even climate change initiatives. PRI is proud today to be unveiling a major new research project on the CEQA Gauntlet. The centerpiece of that project is a giant visualization you see here showing just how difficult it is to navigate the CEQA Gauntlet. PRI Senior Fellow Chris Carr, one of the state's top environmental lawyers, is here to unveil this important project. And he will also discuss reforms with the potential for bipartisan agreement to jumpstart the building of important California projects while also safeguarding the environment. To moderate the session and offer his perspective on the issue is PRI fellow Nolan Gray. You may have read one of Nolan's regular columns on PRI's Right by the Bay blog. He's a professional city planner and a PhD student at UCLA. Nolan's research focuses on land use regulation, housing affordability, and urban design. Most recently, he was a Mercatus Center Frederick Bastiat Fellow, and he is the author of the forthcoming book, Arbitrary Lines: How Zoning Broke the American City and How to Fix It. Please welcome Nolan Gray.
Thanks so much, Sally, and thanks to Pacific Research Institute for having me. Thank you all for being here. I don't normally do prop comedy, but we'll see how this goes. Last week I bought a candle at Marshall's. My mom taught me that trick. And I bring the candle home and I take the lid off. I'm going to light the candle, and there's this cute little note underneath the lid. It says, made in Santa Cruz, California, and it says, we are proof that the California dream is alive and well. I was kind of struck by that. I mean, it's a beautiful sentiment, but it's not something you hear a lot anymore. Some of you might know I'm actually originally from Kentucky, very, very poor state. But my aunt and uncle actually moved out here to California. They were brought out by their military service, ended up settling here in Sacramento, moved out here in the 80s. And even as recently as then, for them, the California dream was real. They moved out here, started a family, bought a home, worked as civil servants their entire lives, built up wealth, created wealth for others. They had the California dream. But today's talk, of course, is about CEQA. So what does CEQA have to do with the California dream? CEQA, at first blush, seems really boring. And as an instructor of undergrads at UCLA, I quickly find out what is and is not boring. CEQA, it's an acronym, and even when you unpack the acronym, it doesn't get any more exciting. California Environmental Quality Act. My undergrads, the eyes would just immediately glaze over. And then when I start saying things like NEGDEC or EIS, then the laptops come out for taking notes. But when you realize the extent to which CEQA is at the root of so much of what imperils the California dream, it becomes hard to think about anything else. Just, of course, this last week, a CEQA case is potentially forcing the University of California at Berkeley to not send out 5,000 admission letters to undergrads. That's 5,000 18-year-olds who might not be able to attend this excellent institution that California taxpayers have spent decades building. Might not be able to get the best possible education they could have had because of a CEQA suit. In my Atlantic piece, I highlight another case, a housing project at First and Lorena in Boyle Heights in Los Angeles. It would have put 49 homes in an area with great transit, excellent opportunity to jobs and opportunity. 24 of the homes would have been set aside for disabled veterans at risk of homelessness. Of course, we're all acutely aware of the homelessness crisis, and we're going to talk about that more today. And the project was delayed by a CEQA suit, a frivolous suit that delayed housing for these people who had served our country and were at risk of living in tents on the street by months. When you scale this up, the CEQA issue, you start to understand how the California dream has become so imperiled, how we've become one of the most expensive states to live in, how people no longer come here for opportunity. Indeed, as we're going to talk about in the next panel, how people have to leave for opportunity. Of course, this is going to be maybe optimistic in a lot of ways, this panel, I hope. Thanks to people like Chris, who I'll introduce here in a moment, and the PRI, there is hope for CEQA reform. Everybody seems to want to talk about CEQA reform. There's recognition that it has problems. So we're going to talk about some of the problems with CEQA today and some of the solutions. And to present on this, we have Chris Carr. He's a partner in the San Francisco office of Paul Hastings, where he chairs the firm's environment and energy practice. He's a senior fellow with PRI's Center for California Reform. He's widely regarded as one of the leading infrastructure development, environmental, and energy lawyers in the United States. Based on his experience working for the U.S. Department of the Interior and the U.S. Department of State, he represents businesses, landowners, public agencies, and nonprofits in environmental and resources law. He has deep expertise in local, state, federal, and international law addressing climate change and driving the energy transition. He frequently defends permits, approvals, and environmental review documents for energy and infrastructure projects in federal and state courts, and he defends against citizen suits brought under federal and state environmental laws against land and resources development projects. He was the ideal choice to undertake PRI's CEQA Gauntlet project, and we're very pleased for him to unveil this important new initiative. Please join me in welcoming Chris Carr.
Good afternoon. It's a real honor to be here. Let me start off with just stepping back a second before we get into the minutia of the California Environmental Quality Act and talk about the big picture. Owen touched on it. CEQA has been weaponized since its enactment a little over 50 years ago. And it is playing a significant role increasingly in, everyone hears and has heard for a long time about CEQA NIMBY challenges to housing, whether it's affordable housing, market rate housing of all sorts. Not as much attention has been given to the impacts of CEQA litigation, and importantly, not just the litigation itself, because there's not 3,000 CEQA lawsuits are filed a year, something like a tenth of that. The threat of litigation, especially for major infrastructure projects, is often as onerous and defeating and fatal as a successful CEQA suit itself. Just real quickly, in terms of the math, unless a local government, regional agency, or even the state government or a private party is somehow financing $1 billion worth of equipment purchases, engineering procurement and construction contracts, and otherwise, if the financing is threatened, that is, if lenders aren't willing to lend at all because of regulatory uncertainty, or will only lend at exorbitant rates, things aren't going to get built. So when you hear people say, and you saw it in the Los Angeles Times editorials of the last couple of days about the UC Berkeley enrollment crisis, where you have people saying, I love CEQA except for this, the legislature should enact an exemption for housing and enrollment at UC Berkeley, and they say CEQA is a great thing, CEQA doesn't really have any impact beyond these idiosyncratic cases. They like to cite the number of lawsuits that are filed, and they studiously avoid talking about the pre-lawsuit impacts of just the specter of CEQA and CEQA threats. So one of the principal focuses of this report is we talk a lot about housing, but we also focus on other infrastructure. And so I've got some props here. Obviously, this monstrosity, what do we call it? Byzantine doesn't do it justice. We could call it Hieronymus Bosch, the horrible plague paintings, right? This is like his hellscape. A picture is worth 1,000 words. And just real quickly to point out here, because we're talking about not just housing, but infrastructure development, CEQA is just the start of it. That's sort of the base. That's sort of California's, CEQA is the Bible when it comes to environmental review and protection in California. In fact, I think it was President Reagan signed CEQA back in 1970. Judge Kolke's shaking his head, yes, absolutely. And, but that's just the start of it. And what we show here is how other permitting requirements, local, state, and federal, depend upon and feed into the CEQA process. So this is the CEQA process, and there's a fold-out in your copy of the report you got. Other typical state permits are over here. California Department of Fish and Wildlife, State Water Resources Control Board for water quality. If you're in the coastal zone, God help you, you have to deal with the Coastal Commission. And then, of course, the regional air quality management districts. The federal side, not as tied into CEQA because the feds federal agencies have to comply with their own version of CEQA called NEPA, National Environmental Policy Act. But just keep this in mind. It's why they agreed that CEQA, our environmental review statute, is NEPA on steroids. So the NEPA issues sort of pale in comparison to the CEQA issues. For all these federal permits that may be needed, if you're impacting wetlands, water quality, species, my goodness, a migratory bird, if unfortunately you're doing that, when you're building, say, a renewable wind energy project. So all this sort of coming together, you start with CEQA, that's the platform, but then on the state and local side, these agencies that have to issue all these other permits to get your project built, they have to rely on the CEQA document too. And so they all roll together, and project opponents realize this, that there are multiple points to intervene. If they don't intervene formally, they threaten litigation, challenge the CEQA document, the rest of this falls away. So again, what we're trying to get across is this isn't limited to housing, and the CEQA issues need to be viewed within the larger context of all the other local, state, and federal permitting that so often needs to take place in order to commence construction on a project of any sort. We'll hear more today this afternoon in the next panel, and then in Stephen's panel, about a lot of the challenges that California is facing. And let me say this up front, other people have said it, I'll say it for myself. I love California. I'm not from here. I'm from Illinois, and I grew up in Illinois, came out here, going to UC Berkeley as an undergraduate. That launched me. I mean, that gave me what I needed in life. And so I feel forever indebted. I was lucky to go there, the great public institution, get a law degree there, and get a PhD degree there. I met my wife out here, and my children are born here. So I'm all in for California. I'm not interested, I mean, it's easy to make fun of California, but this is the greatest state in the country, and we have serious problems that need to be solved, and I think now is the right time, I mean, it's always the right time, but you heard from the district attorney, you heard from Owen, we'll hear more this afternoon. I don't want to use the word perfect storm, but the challenges grow by the day. And so I do think there are opportunities here. So if you look at the CEQA challenges, you know, one recent statistic, US News and World Report ranks us 50th in opportunity among the states, ranks us 49th in housing affordability. Only Hawaii is lower. You probably saw last summer, Ezra Klein of The New Yorker had an article about California's challenges and mentioned CEQA. It's in The New Yorker. And if you've lost Ezra Klein, I mean, come on. So really, what we're facing and trying to address, and again, I'm getting away from private home development, which is the traditional focus. We really have a situation where California is against itself. California is at war with itself and its own felt obligations, policy commitments, goals, and laws across so many areas, not just housing. Look at infrastructure. You look at UC Berkeley enrollment, where that increase in enrollment was all about trying to create opportunity for students who traditionally come from families who don't have the opportunity. So diversity and opportunity is being stifled by CEQA. In the climate environmental area, the state has long been a leader in the environment generally, but in climate initiatives and clean energy. So just give you just two goals, two statutory goals. By 2030, we are to have reduced greenhouse gas emissions 40% below 1990 levels. We're not on track to do that. We're not on track to do that. The amount of renewable energy that's going to have to be built between now and 2030 is insane. for that to happen, particularly solar. CEQA has a lot to do with that. Other climate initiatives. By 2030, 60% of all of our electricity is supposed to be sourced from renewables. Again, how does that happen with CEQA available for use from NIMBYs or from other project opponents? Sometimes labor unions, unfortunately, try to leverage against project developers in that context. Just very challenging. Transportation sector. A lot of the low-hanging fruit has already been picked with renewable energy, and the state's most difficult challenge in reducing greenhouse gas emissions is now the transportation sector. Well, it's very difficult to do that with all the cars on the roads. San Francisco several times has been stymied by CEQA suits when it tried to add HOV lanes. It also tried to add bike lanes. It also tried to have a commuter shuttle bus program to take people from the city down to the tech campuses in Mountain View. The latter, which we were fortunate to be able to defend, ultimately got approved, got through the CEQA Gauntlet, but it's really just a measure of the depth and breadth and reach of CEQA and the challenges it poses. Just another one, in Stephen's panel, we'll touch on this at length, wildfire protection. You all know what we're facing with the brownouts and blackouts, effects of drought, climate change. We have an example in the CEQA report, the CEQA Gauntlet of San Diego program that was held up for 4.5 years, a fuel reduction program to try to create defensible space and protect people and property from wildfire. Delayed 4.5 years by a CEQA suit until they prepared an EIR, which is a gigantic environmental analysis, 4.5 years later. So those are just some of the examples that the report touches upon, and I'll say a little bit more about them in the presentation today. So let me talk a little bit more about infrastructure. And I brought some other props up here. This is the governor's budget, came out in January, $286 million budget. I have it all tabbed because I represent a bunch of renewable energy companies and other infrastructure developers, so this is directly relevant to my clients. That's why you see all the Post-its. But about a half of the pages in here are devoted to infrastructure, including climate change, natural resources, fire preparedness, transportation, and the like. Very, very difficult to realize upon and implement all of these worthy programs and projects with CEQA available as a weapon to threaten or stop those. The next prop. This is from the federal government. As you know, last fall, Congress passed and President Biden signed a $1.2 trillion bipartisan infrastructure law. So think roads and bridges. But there's other stuff in here too. Climate change related, renewable energy, resilient forests, all the same. California's share of that is $45 billion if it gets implemented. And this is a how-to book that was put together by Mitch Landrieu, former mayor of New Orleans and governor of Louisiana, who basically is from the political dynasty there, been around a long time, a lot of credibility, moderate person, practical, got New Orleans rebuilt after the Katrina disaster. President Biden appointed him to be his point person to get this infrastructure package implemented on the ground in the states and in the cities. And in the front of the book, the direction from the president to Mitch Landrieu, quote, "Make sure these programs get implemented without unnecessary bureaucracy and delay to rebuild America's infrastructure," period, quote. In many ways, that's a cruel joke. And it's especially a cruel joke when it comes to California, with what you see there, all undergirded, again, by the CEQA Gauntlet. So the PRI report, a lot of blood, sweat, and tears went into this. Really have to thank Rowena, Tim, and Dana for bearing with us as we iterated this over a period of months. So apologies for the OCD minutia that's reflected in this. The chart is available in a pullout in the back here for you. The report is divided into 3 sections. The first section is about the CEQA process, provides an overview of it, and how permitting interdigitates with that, as illustrated by the chart. The second section is a collection of what we call real-life CEQA horror stories. And they're myriad. And they run the gamut from all sorts of housing, affordable, marketable, market rate, to transportation infrastructure, to renewable energy, and everything in between. So again, what we've tried to do here is bring a little bit of a different focus from what past reports have focused on, which was almost exclusively housing, because we're illustrating, we believe, that even with the goals, policies, initiatives that California sets for itself around the issues that it identifies itself as a leader in, like climate change and renewable energy, clean transportation, CEQA makes it very, very, very challenging. And the fact that those are sort of leading or hallmark policies and programs for California, I actually think creates an opportunity for reform, because it doesn't mean it's just the same usual suspects, my housing developer clients, seeking change. It could be a much broader coalition and much more diverse group of people trying to build things to create the California that California says it sets for itself and that all Californians deserve. Section 3 of the report, we discuss potential reforms. So let me touch first on the CEQA process and permitting. I talked at the beginning about the state agencies needing to rely upon the CEQA document. But let me give a little bit of a background on CEQA documents. And I know Judge Kolke has been litigating CEQA cases for his whole life, so this won't be new to him. And I'm going to try not to get down in the weeds, but it's difficult for us CEQA practitioners to not slip into acronyms. So what are the different types of California Environmental Quality Act environmental review documents? If your project isn't subject to what's called an exemption, where it's been determined by the legislature or under CEQA implementing regulations, there's a class of exemptions that says CEQA doesn't apply to this project, then you are subject to CEQA. And a number of CEQA documents might be confronting you that you need to prepare. At the most onerous is what's called an environmental impact report. And you probably heard that abbreviated as EIR, Environmental Impact Report. And those are often over 1,000 pages long. And that's not excluding, a dozen or more technical appendices, which is the underlying technical expert analysis prepared by consulting firms, by the consulting industry. I'm part of the CEQA lawyer industry, so just to be honest. And those can run another 1,000 pages and cost collectively hundreds of thousands of dollars, if not more. So that's an environmental impact report. Short of that, you'll read about something called a negative declaration or mitigated negative declaration, which we'll just call for our purposes a short form EIR. Again, without getting into the boring minutia. And short of that, you can sometimes get by with something called an initial study that concludes that there is no potential significant environmental impact. Would that were more often the case, right? And another thing to keep in mind is CEQA is a statewide law. So it applies to every corner of the state, to every level of government, city government, county government, any sort of regional agency or authority, joint planning authorities, LAFCOs, the whole slew of land use bodies that Owen's so familiar with and has written about. And then, of course, it applies to the state government. So state agencies, when they're issuing permits, have to comply with CEQA. And again, to oversimplify tremendously, it applies to every discretionary permit. And discretionary is a key word, and it means where the body issuing the permit has discretion to make a decision whether to issue the permit or not. They're not mandated to by law, would be one way to think about it. So the point is, CEQA is absolutely ubiquitous geographically, width, breadth, and also in terms of depth. It affects everything we do in California. We also touch on in the report, in the CEQA process, the time that it takes to prepare these different CEQA documents. So as you can imagine, if you're able to get through with just an initial study and don't have to go on to an EIR, you save an awful lot of time. Sometimes it can take, to prepare an EIR, it can take, best of circumstances, you're looking at a year's delay. More often, you're looking at 18 months, 24 months, and for especially controversial large projects, it could be even longer. Then comes public review of the CEQA documents, where the public, quite appropriately, is informed through a draft I'll use environmental impact report as the paradigm, because that's easiest for our purposes. The public gets to review a draft environmental impact report. This is 1,000-page documents put out on the street. There's a comment period. There'll be one or more hearings at which people get to submit comments, but there's also written comments submitted. And it's during that written comment period that you smoke out the project opponents, or the people who are going to be coming at you to try to stop your project entirely. Say a neighbor doesn't want to put next to their house, and the neighbor happens to be a lawyer, so the CEQA is so easy that the neighbor can bring the suit themselves. Or neighborhood groups, environmental groups don't like where a particular project is cited. You often see this in the Central Valley with renewable energy projects, where there's a lot of disputes, a lot of open space, a lot of land. There's a lot of environmentally sensitive lands out there, a lot of species out there, even though it's the desert, rich in biodiversity. So you have mainline environmental groups that no pun intended, sort of watch over development out there like a hawk, and routinely submit comments in the CEQA process to, say, the county government, which is what's called the lead agency, because they have to issue the conditional use permit for the project. And so you have this whole CEQA public comment process. And the final environmental impact report consists of the draft environmental impact report and the lead agency, its response to the comments that are submitted by the public. And so you end up with these massive, massive documents. In the process, development lawyers such as myself are working closely with the lead agency representing the applicant or the developer to try to create a record, a set of responses in a record that maximizes the defensibility of the CEQA document. So that we can go forward once the lead agency approves the project and certifies the EIR, so that we can go forward as quickly as possible with our project. And then even later than that will come the permitting that we've talked about. Because again, all these agencies over here are called responsible agencies. They're not lead agencies. Lead agency is a CEQA term. But these agencies typically rely on the CEQA document prepared. The permitting agencies, the responsible agencies, typically rely on the CEQA document prepared by the lead agency. So you can see the cascading effects on your project development timeline if you've got a CEQA challenge to deal with, or even the threat of litigation. Project approval and certification of the EIR, then there's the opportunity for CEQA litigation. There tend to be fairly short statutes of limitations, that is the time in which a suit has to be filed. It doesn't drag on for years, so you know relatively soon. There's a gigantic administrative record that's prepared that's going to be the collection of documents upon which the court renders its decision as to whether CEQA was complied with. Oftentimes, and this goes to the leverage that the project opponents like to exercise when they know that a project is up against it on a timeline because of financing, development financing, or has other commercial obligations. Say you have to start providing electricity to, if you're a solar farm, you have a contract to provide electricity to, say, PG&E by a date certain, and if you don't, you face huge liquidated damages because they have to go out and cure and find substitute energy. And so project opponents know that, and so they file a CEQA suit, and when they go to the mat on it, they will come into court and ask for what's called a stay. They'll say, Judge, please put a hold on this project construction going forward because we have this suit, and if this construction goes forward, sort of then, you know, the damage is done if we end up being right. And California courts, I think the doctrine, try to characterize it fairly, California courts are not reluctant to issue stays to preserve the status quo, and frankly, the financial impacts on the project developer don't get much consideration in that process. And then last, in the litigation context, are the attorney's fees. And to simplify, under California's Private Attorney General statute, Code of Civil Procedure 1021.5, again, to simplify, it provides that a prevailing CEQA petitioner is entitled to have its attorney's fees paid for. It doesn't go the other direction. It's unilateral. It's one way. And then as a practical matter, my clients, project developers, also typically have to sign reimbursement agreements with the lead agency, like a county or a city that's preparing the EIR, and pay, of course, for the preparation of the EIR, but also for the county or city to defend the EIR, regardless of whether they win or lose. So you can see, again, these cascading costs, cascading effects. It's a real challenge. Quickly turning to section 2 of the report, the real life horror stories. We look at more than half a dozen examples, all types of housing, from affordable to market rate. Habitat for Humanity projects. There was one in Redwood City in the Bay Area where I live, where, and I wasn't joking earlier when I talked about the neighbor being a lawyer, where the neighbor literally was the lawyer and complained that out of his back window from his home office, his view would be negatively impacted by a Habitat for Humanity project going in. Years of delay. It ultimately got through the CEQA Gauntlet, but this is not a big project, $13 million project. Ultimate cost, $17 million. $4 million in additional costs because of the CEQA process. Ongoing dispute right now involving University of California, San Francisco's great flagship campus, the Parnassus campus. Long-term planned expansion there. 3 lawsuits pending. People wanting different things. Everyone swears they don't want to stop the project. They just want to influence its precise configuration. So we'll see what happens there. But there, Californians, really people around the world, are being denied by these CEQA suits the opportunity to avail themselves of the health care that our great public university hospital provides. sort of a beacon for the world. So again, California against itself. Los Angeles, it was a measure HHH to address homelessness, a special ordinance. Well, that was challenged. CEQA suit, bunch of them. They had to go to the legislature in 2019 and get an exemption from the legislature for projects that were funded by HHH. This is sort of, housing for the homeless. Of course, no list of CEQA horror stories would be complete without the latest insanity raining down from San Francisco. City I love, just like I said, love California, love UC Berkeley. We cover myriad housing projects in there, including affordable housing projects that have been stymied, often because they weren't 100% affordable. And so there's this question of, well, how's it going to be paid for, right? I mean, if you have 100% affordable housing, who's supposed to pay for this? But those questions don't really factor in often when it comes to CEQA in San Francisco. Most recently, this past fall, there was a 495-unit project, included affordable, market rate housing, everything in between, right downtown on a vacant Nordstrom parking lot, next to BART, next to Muni, next to the bus. So you have density, you have dense housing right next to regional transportation on a vacant parking lot. The Board of Supervisors nixed it by an 8-3 vote and said, go back to the drawing board. They had literally an EIR that was, excluding appendices, 1,129 pages. They'd studied it for 2 years. Board of Supervisors responding to not so much neighborhood pressure, but as people in the Mission, housing advocates saying now it needs to be 100% affordable, otherwise we have gentrification. They said go back to the drawing board and redo the seismic analysis and then come back to us. So they just put it on hold. This prompted, frankly, outcry from Mayor London Breed, who I think used the word insane and said, is it any wonder we have a housing crisis here? State Senator Scott Wiener had even more choice words for that. The AG launched an investigation as to whether the Board of Supervisors is violating certain housing laws, and the legislature seized of the issue. So again, the time is right. I mean, we'll see what happens. The legislature seized now of the issue of the Berkeley enrollment, where last week, the UC president testified in front of Appropriations Committee, and Kevin McCarty of Sacramento area asked, well, what can we do about this? And the UC president said, well, it'd be really helpful if you looked at the applicability of CEQA and reach of it to our enrollment decisions. And then the UC president quickly caught himself and said, but we love CEQA, we think the environment's the most important thing, we really don't want to undermine CEQA, right? So you see the challenges. On the San Francisco one, just one other example, the head of the San Francisco Building and Construction Trades Council, outraged, said after the supervisor's vote, he said, it's great to build 100% affordable. If someone wants to come and buy the property and do that, quote, but hurry, because I've got families with kids to feed, close quote, because it would have created 200 construction jobs for 2 years. These are union jobs. Board of Supervisors didn't care. Public schools are also covered. CEQA being used to block public schools. We touch on wildfire risk reduction, which I mentioned at the beginning, and Steve's panel is going to go into detail on. Transportation, traffic as well. Touched on that a bit. HOV lanes have been blocked. Bike lanes have been blocked. I mentioned the Google bus case. Think about this for a second. Again, California mandated itself to get to 40% of 1990 greenhouse gas levels by 2030. At the same time, the most congested in the cities in the US are this: number 1, Los Angeles; number 2, San Francisco; number 5, San Jose. At the same time, you've seen the governor's mandated by 2035, all new cars will be electric. Well, electric vehicles have to be charged. It's electricity. So where does the electricity come from? California says it doesn't want to get more electricity from natural gas. You see all the moratoriums on natural gas hookups in place. Things are coming together. California needs to stop being at war with itself. Last I'll touch on in terms of horror stories of renewable energy. I noted the 60% renewable sourcing by 2030. Just last week, the California Independent System Operator came out with a report, said California needs to have 120 gigawatts of electricity. We currently have 80 by 2040, with one half of it coming from solar. So that's not going to require just a massive build out of renewable energy. And the energy intensity and efficiency of solar is improving, so you get some relief there. The panels are more effective, so you need fewer of them, so you need to cover less space. But it'll also require a massive build out of battery energy storage systems. Well, people don't like those because they require batteries and lithium ion, and so you file a CEQA suit. Again, very difficult, as I mentioned, the financing, big renewable energy projects. You've got to purchase solar panels, it'd be tens of millions of dollars. Battery plant, even more expensive, can be hundreds of millions of dollars to purchase the batteries. Then you have to pay the contractor, EPC contractor, that can be a $70 million contract. All the while you're trying to get investors to take a piece of your project, traditional investors, lenders, but also tax equity investors. And so you can just see, again, the cascading effects and the proliferation of cottage industries around this, including mine as a lawyer, needing to advise on the lender investor on the diligence here, sort of what's the risk that this will be delayed in a material way or never come to pass. So let me turn last to CEQA reform, the third section of the report. It's an historic third rail for the legislature. There's just a litany of lines that encapsulate this. Our former governor, Jerry Brown, famously remarked, I think in 2017, that CEQA reform is the Lord's work. And then he said, but the Lord's work often doesn't get done. He's a former seminarian, of course, so you can say that. But, just very challenging when you have a lack of political competition like we have with one-party rule. It just makes it very difficult to get things done in a meaningful way when there are substantial and important interests that like CEQA the way it is because it provides them leverage or advantage. So just to touch on a few of the reforms, an easy one for me because I defend these CEQA suits on the back end of trying to get projects developed after hopefully working up the EIR in a way that's defensible. But one potential litigation reform is legislation requiring the filing of CEQA suits in the first instance in the Court of Appeals. And potential benefits of that is that plaintiffs are going to think twice before willy-nilly filing CEQA suits. They won't necessarily get a home county judge because there are fewer courts of appeals, and the courts of appeals, each of them have a number of counties under their jurisdiction. There's also the filing of CEQA suits in the district courts of appeals in the first instance would also give those courts an opportunity to develop the CEQA doctrine and procedural doctrine to I would say, manage their caseload would be one way to think about it. They could do it a number of ways. They could try to tighten the standing requirements. In federal court, you have this Article 3 of the Constitution requires you to have standing to bring suit. We don't really have that in California court. There's something that roughly approximates it called the beneficial interest test, but giving that more teeth would be one way to perhaps limit some ill-founded CEQA lawsuits. It could also tighten the standard for frivolousness, was mentioned earlier, frivolous lawsuits. California courts have been historically exceedingly reluctant to find that a lawsuit is frivolous. The idea is keep the courts open as much as possible, access to justice. On the reform of requiring filing first in the district courts of appeal, I'll note that the legislature did take a shot at that several years ago, and a very senior and experienced judge in Alameda County, who has been the CEQA judge there for a long time, struck that down as unconstitutional, saying that it violated the separation of powers, essentially. But that was just one judge, and that judge deserves our respect. Judge Roach has a long and distinguished career, but it wasn't appealed, so there's no appellate case law on it. So the issue from a legal perspective remains open, and we would suggest that another run be taken at that. Another type of reform is to bring more sunshine on the CEQA litigation process. Range of steps could be taken, including requiring public disclosure of the funders of CEQA suits. So when the plaintiff's attorneys go around passing the hat, maybe it hits a certain threshold if it's $500 or above, let's know who that is. I mentioned attorney's fees. That's historically trying to make that bilateral or symmetrical so that prevailing defendants can also collect fees. That's sort of been a holy grail of CEQA reformers for years. It's nice to ask for it because it sort of sets a bar out here or here. It's not going to happen. The legislature will not do that. Plaintiffs bar, other interests who like CEQA the way it is. One structural reform, emblematic of a class of reforms that could be considered, would be a legislative moratorium on CEQA exemptions. We talked a little bit about exemptions and heard about it. And the legislature in the last few years has increasingly used its enactment of its passing of exemptions have to be signed by the governor to be enacted as a safety valve when the heat gets too hot or when there's a project that just has to get built, like SoFi Stadium where the Super Bowl was. It gets a CEQA. It wasn't exempt entirely from CEQA, but it got special streamlining treatment. But we propose that the legislature consider an exemption, a moratorium on issuing exemptions on one-off projects. Of course, in any given instance, that law could be overridden to again give an exemption for one-off project, but at least it puts everyone on record, has to be more transparent, and we think that it would put the sort of pressure that's needed on the legislature to look at comprehensive reform rather than this sort of one-off safety valve with exemptions, where the legislature gets to, as it were, punch a ticket for particular individual projects. And so those three sections comprise the report. We hope you enjoy it. Just in closing, we talked about the weaponization of CEQA. In many ways, sort of our view is with California's challenges and opportunities, CEQA has increasingly become a proxy for other larger disputes and challenges that we're facing, distributional challenges, equitable, legitimately conflicting challenges between environmental conservation and other pressing public needs. So it's not going to be easy, but we think the time is ripe for pushing hard now. So thank you for listening.
We have time for one question.
Tim, you were supposed to hold up the...
So I live down in Santa Cruz County, and in the fall of 2000, had to evacuate my community because of the CZU wildfire. In the year and a half since that fire was extinguished, only 80 building permits of the 1,000 houses that were destroyed have been issued, which means 920 families are still living in temporary housing. Their children's schools are closed or they're having to attend other schools. I mean, it's really torn the community apart on many levels. And I know this is replicated in other communities around the state and in your home state of Kentucky, as we saw destroyed by the tornadoes, what effect is CEQA having on building departments, which you mentioned earlier, have discretionary authority to grant building permits to allow people who had homes to rebuild them?
That's a great question. Owen is Kentucky. I'm Illinois, but the Midwest. Yeah, there you go. The things in Santa Cruz are very challenging because that's always historically been a very environmentally conscious county and community. But you're right, the phenomenon is being replicated around the state, and the challenge for the people in the planning departments is even when they sympathize with the need to sort of get things permitted and under construction to help the community, there's always going to be so-called CEQA watchdogs around who are going to threaten litigation. And so they're on a daily basis, cities, counties, really state agencies trying to build things too and permit things, are put in a situation where they're always trying to weigh the risk that they'll face a CEQA suit. And then they start thinking about who's going to pay if we lose. Do we have to pay the plaintiffs? The answer is yes. Who's going to pay our fees? If there's not a reimbursement agreement with a private developer, it's on the city or county. And so they've got a real tightrope that they have to walk. So even the best intentioned planning department folks have a real challenge because of CEQA.
Well, join me in thanking Chris, and thanks so much.
If you like this episode, please tell your friends and subscribe to PRI's podcast at iTunes, Google Play, Stitcher, TuneIn, iHeartRadio, and Spotify. And when you're on these platforms, don't forget to give us a big 5 stars. If you don't subscribe to any of these, you can still listen on PRI's YouTube page, youtube.com/Pacific Research 1. That's the number 1. Thanks for listening. I'm Rowena Itchon. Hope you'll come back again for next round with PRI.